The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 921, coming to you on Monday the 3rd of December 2018. On this program, I will speak to you on the topic, the Eastern Caribbean Court of Appeal, but on your screen you will simply see the Court of Appeal. But before getting into the topic, a few preliminary comments. Firstly, and as usual, my condolences go out to all families which have suffered recent bereavements. And in that connection, my special condolences go out to the American people on the death of former President, the 41st President, George Herbert Walker Bush, who will be laid to rest on Thursday. Secondly, I would like to congratulate the St. Vincent and the Grenadines Cricket Association on a very lovely, produced and organized National Awards dinner. Formal dinner held at the Anna's Vale playing field in front of the Players Pavilion. Setting beautiful as usual, and my congratulations to the President and executive members of the Cricket Association. Of course, many years ago, I served for a few years as Vice President of the Cricket Association under firstly Dr. Cordis and then under Mr. Lennox John. And I'm a life member of the association, so I want to thank you all very much for the invitations. The only matter I would express a bit of a disappointment about, not about the awards themselves, not about the dinner, but for the second time in recent years, certainly year before the last, I didn't make it to the dinner last year, unfortunately, but certainly year before the last and again this year, the ministry under which cricket falls was having the same night as the Cricket Awards dinner, having other awards elsewhere. And it occurred to me that the ministry officials ought to see if they cannot stagger their functions, because when, award after award, we go, the Minister of Sport can't be there because he's attending another function held by his ministry and other awards and so on. It doesn't augur too well, so that I would hope that next year, Divi, they would find a way of having these functions for the same ministry on different nights. I want to say finally my congratulations to all of the awardees, and in particular to the Youth Cricketer of the Year, young Mr. Rayon Williams, who is a member of the youth group of my church, Belmont St. Elizabeth Spiritual Baptist Church. Keep it up, Rayon. We are all very proud of you, and we are glad that in church on Sunday you acknowledged that the Lord was the author of your prowess in your chosen sport of cricket. Let me say this about cricket. For some years, ever since the T20 format started, I have been wondering, when are they going to introduce 2 innings T20, or I should say 4 innings, so that you have the teams batting 20 overs, the first team, the next one 20 overs, and then you have a second innings where the teams go in again. It seemed to me that might generate a lot of excitement if the performance of a team in the first innings can leave them with a mountain to climb in the second innings and they do climb the mountain. And now that I'm hearing about T10 cricket, well, T10 cricket is ideally suited for 2 innings, not just the one of 10 innings one side, 10 innings the other side. So I hope the organizers will think about that, and if in years to come you hear that there is 2 innings T20 or T10 cricket, remember that you heard it first on the Law and You. All right? Well, on the 21st of November, my 40th anniversary of the call to the bar passed quietly by. Yes, I was called to the bar on the 21st of November 1978 at Gray's Inn in England, so that I've chalked up 40 years, thanks to the good Lord. All right, topic for the evening, the Eastern Caribbean Court of Appeal. Now, next week, the Court of Appeal would be sitting in St. Vincent and the Grenadines from Monday to Friday. As the vast majority of you would know by now, the Court of Appeal comes here usually 3 times a year, occasionally twice per year. The Court of Appeal is an institution which services the whole of the OECS. So the Court of Appeal sits in the British Virgin Islands and in all of the Leeward Islands, Antigua and Barbuda, St. Kitts, Montserrat, and it sits in the 4 Windward Islands, Dominica, St. Lucia, St. Vincent and Grenadines, and in Grenada. So the court travels from venue to venue. Quite a lot of traveling they do. And usually they sit for a week in each place, and our turn is coming next week. Let me take the opportunity, in case I don't get it, to welcome the Court of Appeal when they come to St. Vincent for their tour of duty here. Now, occasionally you hear somebody who has had a case in one of the courts, either the magistrate's court or the family court or the high court. You hear somebody say, look, I am not satisfied, I lost my case, I want to appeal. That is, of course, a natural reaction from somebody who has lost the case. But it doesn't follow that because a litigant is disappointed, it doesn't follow that the litigant has any good grounds to appeal. And therefore, if the litigant who has lost the case in either the High Court or one of the other courts wants to appeal, the first thing the litigant should do, if he or she has a lawyer, is to discuss it with the lawyer. The lawyer may well feel, look, it is a waste of time appealing because of any number of reasons. The lawyer may be disappointed with the decision, but he may agree with the decision. And when I say he, I mean she. Or the lawyer may realize, well, look, there's nothing we could really appeal on here, so let us, leave it at that. I mean, it's hard for some lawyers to look at a client and say, look, sorry we lost the case, but there's really no ground for us to file an appeal. Person might get disappointed and might say, look, I'm going to another lawyer to file my appeal. Person may go to another lawyer with his or her papers, and the other lawyer may look at the papers, look at a copy of the judgment, or take account of the decision, and may advise the person, it's no point appealing. On the other hand, the other lawyer may say, okay, if you want to appeal, let's appeal. It's going to cost you so much and so much. Bring the money and we'll file your papers. Now, When an appeal is heard, it isn't starting over the case all from the beginning. That is not what an appeal involves. The appeal judges, and there are 3 of them who normally will sit on each case. More than 3 are appointed. Sometimes you have as many as 5 or 6 appeal judges, some acting. And they come to the jurisdiction, 3, 4, 5 of them, as the case may be. But on each case, on each appeal that the court hears, 3 judges sit on the panel. Usually the extra judge has other related matters dealing with in another venue, at another, for example, the appeal court sits downstairs, the main courtroom in Kingstown, but at the same time, one appeal court judge who is not sitting in the panel may be upstairs dealing with procedural matters or other applications and so on. Now, when the court is sitting to hear an appeal, the court doesn't hear over the witnesses. The court depends on the documents which are placed before it. Central to those documents is one called the Record of Appeal, usually a bound volume, and it has in all the main documents that the Court of Appeal is concerned with. Now, you would immediately understand that if there is going to be an appeal process, that process must have a time limit. For example, if you get a decision on the 3rd of the month, say the 3rd of October, you can sit October, November, December, and in February say, look, I want to appeal this. Why not? Time has passed. So the rules say if you are contemplating filing an appeal, it has to be filed within a given period of time. If it is a high court matter in which leave is not required, the period is 6 weeks. If leave to appeal is required, you have to file the application for leave in 2 weeks' time. If you're in the magistrate's court, you get a decision against you and you want to appeal, you have 2 weeks to file the appeal. Similarly, if you are in the family court and the decision goes against you and you want to lodge an appeal, you have to lodge that appeal within 14 days, 2 weeks. You can't sit about and let time pass and then say you're going to appeal. Of course, the rules say that even if you are late, you can still apply to the court to extend the time to cover your lateness. That is called an application for the extension of time within which to appeal. And the rules have a number of factors which have to be taken into account in the court deciding whether to give you the right to appeal out of time or whether to say, no, you are out of time, you haven't satisfied the conditions, your reasons are not good enough, the delay was inordinate, the prejudice to the other side would be too strong, and so on. So that's the first thing I want you to understand. If you have a case and you want to appeal, there's a time limit within which the papers have to be lodged. Otherwise, crap or smoke your pipe. You're out of court, out of time. Unless, as I said, you can show strong reasons why the court should give you additional time, and you have to come really strong to persuade the court to do that. Now, generally speaking, there are two types of appeals: appeals in civil matters and appeals in criminal matters. Appeals in civil matters are appeals arising mainly out of the High Court in its civil jurisdiction. Appeals in criminal matters arises from the criminal assizes and from decisions of the magistrates' court and the family court in criminal cases. In criminal appeals, there are again two types of appeals, usually. One, appeals against sentence, and secondly, appeals against conviction. Well, I should put it the other way around. Appeals against conviction and appeals against sentence, or both, an appeal against both conviction and sentence. When a person is appealing against his or her conviction, the person is saying, I was found guilty and the court was wrong to have found me guilty. That is appeal against conviction. That is, you've been convicted and you want to challenge the conviction. You want to say, something went wrong, I wasn't rightly convicted, so I want the court of appeal to look at this, that, and the other. But sometimes a person is content with the conviction, but feels the sentence has been too severe. So the person says, look, okay, you have found me guilty, I'm not challenging that, but the punishment imposed on me was too much, too severe in the circumstances. I was a first offender, or the fine was too high, or the number of years imprisonment was too high in my circumstances. And you are inviting the Court of Appeal to agree with you and to give you a lesser punishment. That is when you appeal against sentence. You're saying the sentence was too strong, too much. Punishment is more than I can bear. And let me give you a little legal joke about that. The story goes that there was this old man in his 70s who was convicted of carnal knowledge. That is, he had interfered with an underage girl. And at the criminal assizes, he was convicted. And when it came to the sentence, the judge imposed on him a lengthy sentence, I think something 18 years. And he complained to the judge. He said, my lord, 18 years at my age, I can't do 18 years. I can't make it. I wouldn't last. And the story goes that the judge looked at him quite sympathetically and says, well then, if you can't do the 18 years, do whatever you can. I hope you got that. So just do whatever of the 18, do whatever you can. All right. So back to the narrative. In the High Court, there are two circumstances surrounding your ability to appeal. One, There are circumstances in which you, the losing party, have a right to appeal. And two, there are circumstances in which you, the losing party, do not have the right to appeal, but you have the right to apply for permission to appeal. Hope you understand the difference. In cases where you have the right to appeal, you don't have to ask anybody permission. Once you are within time, you file your papers. But where you need permission to appeal, and the law uses the word leave to appeal, then you have to ask the court to permit you to appeal. Technical differences distinguishing the two situations. Where you have the right to appeal, you generally have the 6 weeks. But where you need permission to appeal or leave to appeal, you have to apply for that leave within 2 weeks' time. Usually in procedural matters or decisions of the court which are not final. That is, notwithstanding the decision, the case goes on because there might be other issues involved in the case. From what I have said, you would have gathered that the documents you file in support of your appeal are crucial because those documents are all that the Court of Appeal has to go by. And therefore, it is important that you place before the Court of Appeal all documents which are relevant to your case. If you're going to appeal and the decision involved an examination of a lot of documents by the judge, when you file your appeal, you have to be extremely careful to make sure that the papers you put before the Court of Appeal are relevant to the appeal. Generally, in the stage of preparation of the papers, the two sets of lawyers, assuming that the appellant has a lawyer and the respondent has another, and the respondent is a name given to somebody against whom an appeal is brought, the appellant is the person who has appealed. Usually there comes a time when both lawyers get together and decide what documents should go before the Court of Appeal. Not every single piece of paper has to go before the Court of Appeal, but every single relevant document should be placed before the Court of Appeal, because it is reading those papers and listening to the lawyers when they come to argue the appeal that enables the Court of Appeal to decide whether to allow the appeal or to disallow the appeal. Generally, the Court of Appeal has the power to change any decision made by the judge or magistrate from whom the decision has the decision to appeal has come. Court of Appeal can change by increasing or decreasing, can substitute new orders in place of the ones given by the judge or the magistrate, can throw out the appeal, can order a rehearing. That is, the Court of Appeal can say, for these reasons, we want the judge to hear over the case, or another judge to hear over the case. Remember not too long ago in the case of the election petitions, a decision was given against the petitioners. They appealed. The Court of Appeal said, we agree with the complaint you've made. let us get another judge to look at the complaints again. So unfortunately, that was done, and that is taking a lot of time, and the matters are still before the court process. Therefore, the powers of the Court of Appeal are enormous, which means that time and care have to be taken to make sure that the documentation is in order and that the Court of Appeal has everything before it that it needs in order to come to a just conclusion. One of the most important documents in any appeal is a document called the transcript of the proceedings. The transcript of the proceedings consists of all that took place before the judge or the magistrate. That is, all the evidence given, what all was said in court, all the arguments made, and so on. So after a case is finished, once an appeal is lodged, the authorities at the registry have a duty to get hold of the transcript and print out all the evidence heard in the case and all the transactions which took place during the hearing of the case. That is where we have a problem here in St. Vincent and the Grenadines, because we do not have enough trained stenographers in the system to produce transcripts at a reasonable stage. And there's a huge complaint that people have lodged appeals and are waiting for months, sometimes years, on the transcript, without which the appeal papers cannot be completed. So that sometimes you find people complaining that the lawyer is taking a long time with the appeal. It's not the lawyer's fault. The lawyer simply has applied for the transcript and is waiting for it. In fact, arrangements have been made for documents to be, for stenographers to be brought in from other places in certain important cases so that transcript could be produced in a timely manner. But what I want you to understand is that when a case is appealed, the Court of Appeal doesn't hear the witnesses afresh. It deals with papers, documents. And those documents are the foundation for any appeal. Okay? All right, well, the time is up, so that is all from this program on this fascinating topic. This program number 921 of The Law and You. We're now into the Christmas season, and mornings have been launched, and let us hope we have a peaceful and enjoyable Christmas season. So I look forward to being of further service to you next week, Monday DV, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC, and brought to you on SVG-TV as a public service.